Good afternoon, everyone. My name is James Cousins, and this is
Melissa Day.
And we're with the law offices of Melissa Day, LOMAD.
Coincidentally.
And we're here to give you a live webinar this afternoon. We're going to talk a little bit about math. Sorry, math is really boring. I know when I became a lawyer, sometimes it was to avoid math. A lot of people became lawyers, I think, to avoid math. There's a lot of math in workers' comp. And today we're going to be talking about average weekly wage calculations, C240s, and strategies and concepts that you need to understand to properly navigate the beginning of a claim, potentially save money. And I just want to give a disclaimer. This is not legal advice. We are not your attorneys, although we do represent some of you out there. And for those of you who don't, maybe you'll change your minds. But this is not legal advice and should not be taken or construed as such. If you have questions about a particular case, feel free to email or call us, and we'd be happy to help.
So we'd also like you to grab your calculator or your smartphone because we are going to ask you to do some math. Hopefully it won't be too onerous, and some scratch paper. All right, let's get right into it. The place to start, as I tell all my attorneys all the time with workers' comp, is you start with the statute. Section 14 is where you'll find the law on how to calculate an average weekly wage. And what you have before you right now is Section 14.1 of the Workers' Compensation Law, which provides you with the starting place for how you're going to calculate an average weekly wage.
And this gives us our multiples, our multiple methods of calculation. 14.1, our 200, our 260, and our 300 multiple.
I've underlined the critical parts of the statute that I want you to pay attention to and that we're going to discuss during the presentation. One is that the employee has to have worked during substantially the entire year prior to his injury in order to use Section 14.1 to calculate his average weekly wage. And then the second part of it, which is important, are the multiples that James just talked about. You'll use a 300 multiple in a situation where somebody is a 6-day per week worker, and a 260 multiple if somebody is a 5-day per week worker. Now you're asking, what the heck is a multiple?
Well, a multiple is a really strange and sometimes overly convoluted way to figure out how to calculate an average weekly wage. It also usually means that we end up paying more than what you might with just a straight divisor. So to put it in words, the simplest thing you do is you figure out how much they earned per day where they were actually worked is in air quotes, and then you multiply it out by the multiple to create a synthetic yearly earning, and then you divide by 52.
So the formula is gross wages for the year prior to the injury, the number of days that they worked. You're going to divide that into the gross wages. Then you'll multiply it by 260 if they're a 5-day per week worker, or 300 if they're a 6-day per week worker, and then you're going to divide by 52. So for an example, let's take a look at somebody who earns $45,000 the year prior to the accident, and they work for 253 days. And we are going to take for granted, based on some information we have, that they're a 5-day per week worker, which you don't always have to do.
And the way it works out here is you're going to see that the average weekly wage of $45,000 is divided by the 253 days the claimant worked. You get $177.87 a day. That's their average daily wage. Now you apply the multiple. You multiply by 260 to get an adjusted income of $46,245. You divide that by 52. Your average weekly wage is $889.33. Just as an aside, from a mathematical perspective, we have credited the claimant with 7 days of earnings that they didn't actually work. That's what the multiple method of calculation typically does in most of our cases. It credits a claimant with some days that they didn't actually work.
All right, so now we're going to take a look at another example, just to make sure that this is going to become second nature for you, and we're going to compare different kinds of ways that you could calculate the average weekly wage other than using the statute and the multiple. So for this example, we'd like you to assume the claimant earned $51,750 during the year prior to the accident and did 225 days of work. But that 225 days was done actually only over a period of only 50 weeks of work. You don't actually have the full set of 52 weeks of wages. We have 50 weeks of wages for that year prior to the accident. So we'd like you to just compare conceptually some of different ways that you could calculate an average weekly wage.
Well, if you just do a straight divisor, which according to case law, innumerable doesn't exist as a matter of law. It's not a divisor, but it's called an actual multiple. we divide by 52, you get $995.19. But if you take the wages divided by the number of weeks worked straight ahead of 50, you're going to get $1,035. And if you take it as a 5-day worker using the multiple method of calculation, you're going to get, surprise, the highest result, $1,150 for that average weekly wage.
And so this is just for you to be able to compare that if we use a divisor of 52 weeks, that's sort of like how people would envision an average weekly wage in the real world, not in Compland. You're going to get the lower average weekly wage in this scenario compared to the 260 multiple. Now we'd like you to pull up the examples that you have received by email prior to today's presentation, and then that are also in the chat for the presentation. So we'd like you to look at example number 1 in that packet first. We're going to do some math based on that.
So we have our claimant, ouch, it hurts. Melissa came up with these names. Who's a day laborer? And you're going to see that he's tagged as a 5-day per week worker. So the first thing for this example is we know we're going to be using a 260 multiple method under 14.1. And the gross wages reported under number 5 are $52,920. Now, if you also look on number 5, it tells us 210 days were worked. If you flip to page 2, I almost never look at page 1, to be honest with you. I always flip immediately to page 2. But if you look at page 2, you're going to see our scatter plot, essentially, of the data about how many days they worked for each week. So the first question we're going to ask you is when you're examining both pages of this C240, we're hoping that you can help us by identifying 3 issues that could potentially cause problems with this C240. And I guess problems means problems increase liability, problems that could prevent it from being set firmly or require additional information later on. And then we're going to calculate the average weekly wage. So
we'd like you to think about 3 issues that you might be able to identify with this C240, with the wages that were presented for the claimant. And then we'd like you to use a 260 multiple to calculate the average weekly wage. I would like you to also take note that on the first page of this C240, there is an indication that the claimant is a 5-day per week worker. So that's why we're just going to go ahead and use a 260 multiple here. But look at the weeks of wages that have been provided by the employer here and see if you can identify any anomalies. On to our next slide. Okay, hopefully you noticed with the wages that were provided that for weeks 34 and 35, there are wages listed, but there are 0 days of work listed. It seems to be something that merits looking into to find out how it is that somebody could get paid and not have to work anything. Or I definitely need to go and work for that employer. The other thing that we'd like you to notice, 5-day per week worker, this person was denoted as a 5-day per week worker on the first page of the C240, but there are only 210 days of work for the entire year listed. If somebody truly worked 5 days per week every week of the year, they would work 260 days during the year. This person worked 50 days less than 260, according to the information provided on the C240. And then lastly, there are no wages listed at all for weeks 1, 2, and 3. And we would want to inquire, like, well, why is that? Did the individual start? Then there actually isn't a full year's worth of wages? Or is it that the individual was on an unpaid sabbatical or something in Europe? So to calculate the average weekly wage, James, you want to take that away?
52,920 gross earnings divided by the 210 days worked gives us a daily wage of $252. That's what they actually earned on a day that they really worked. To apply that multiple again, what we're doing this time is we're crediting them with 50 days of employment at that $252 rate that they didn't work. And so their adjusted gross income is $65,520. Divide that by 52 weeks, you get an average weekly wage of $1,260. And if you look, this is one of the first red flags. If you look at this payroll, you're going to see, That's more than it appears that they ever earned, except for what, 1 week, maybe 2, out of the entire 50 weeks that they actually worked. That's a problem.
If you're having trouble locating the packet, please go up to the chat section at the top of the Teams presentation, and you should be able to access the documents from there. If not, we did send out an email to all participants this shortly before the presentation, and we provided the sorry, we're having a bit of an audio issue. We provided the samples with that email. Okay. What we'd like you to do now is look at example number 2.
Ouch, it hurts. He's once again tagged as a 5-day worker on page 1. You'll see that under section 3. He's paid hourly. Question 4, he's tagged as a 5-day worker. Gross day wages are the same, $52,920, 220 days worked, right? But now what we're going to do is identify that some of those days that were earned, where there's earned income, but no days worked, we're going to assign days to those. And the reason we're going to assign days to those is pretty simple. The statute says that days so employed, not days worked. So we keep saying worked. We keep using the word work. That's not what the statute tells us. The statute tells us it's days so employed. Fort Orange Paper Company makes it clear that somebody actually read the statute and made a decision based on that. And so we get days credited for vacation. So if somebody takes any sort of PTO that has a day equivalency or an hour equivalency to it as the employer or the carrier, you get to take credit for that time. So we can increase that denominator and hopefully help limit the average weekly wage exposure. So in this case, our calculation now adds up to $1,202.73, which means by simply crediting those vacation days to ourselves as is appropriate under the statute and case law, we've saved $57.27.
Right. And you might be thinking to yourself like, oh, wow, that's great. I've saved $57 and I did all that work and contacted the employer and found out that the person was actually getting PTO during that time. I'm not sure that it was worth it. Part of what we're going to look at in a little bit is how those savings can add up exponentially when you're looking at permanency awards.
Or even just extended periods of temporary lost time.
Absolutely. So now what we're going to do is move on in the statute. We've looked at what you would do when you have a 5 or a 6 day per week worker who has worked substantially the entire year prior to the accident. If the person did not work during substantially the year prior to the accident, then you need to get similar worker payroll. So section 14.2 is the section after section 14.1, which describes how to calculate an average weekly wage when the individual did not work for substantially the whole of such year prior to the accident. If they're a 6 day per week worker, you're going to use the 300 multiple using the similar worker payroll. And if they're a 5 day per week worker, you're going to use a 260 multiple using a similar worker payroll. And the important feature of this section of the statute is the description of a similar employee. It's an employee of the same class working substantially the whole year prior to the injury in the same or similar employment. Right, so let's take a look at what kind of factors are taken into account in determining whether or not an employee can properly be considered a similar employee.
And some of these are obvious, some of them less so, but they're obvious problems we encounter. Our typical injured worker is injured like immediately after they're hired, and they're usually at the lowest rate, right? I mean, that's one of our red flags. They're hurt right away. And the similar worker, the only other person who's a similar worker has 5 years of seniority. They're not really similar because they weren't hired at the same time, and they certainly aren't receiving the same hourly rate. Are they in the same department? Are they in the same position? Do they have the same or similar job duties? What about their title or their location? Geographic location, especially we know in New York, makes a big difference. Are they on same or different schedules? This is common in large unionized shops or industrial settings where we might have the folks that are on A or first shift that running the day, and B shift, they're totally different jobs or different earnings.
Or differentials for the shift.
And then, of course, at the end of the day, the sole purpose of this is to find somebody who has approximately the same earnings per week as the employee in question. We just don't have enough data, even though the multiple method of calculation allows you to extrapolate an average weekly wage using almost no data points, very few data points. That's its only benefit to us. And so, but you also have to remember, they also have to have themselves worked for substantially the whole of the entire year prior to the date of accident. So just producing somebody else who would then themselves require similar worker payroll is not going to be helpful. Bear in mind, very few employers really have businesses or of the size or of the type where they would be able to identify somebody. That's what we tend to run into as defense counsel.
So most employers in this country are small businesses, and they don't hire and employ thousands of individuals from which they could just extract somebody who's similar to an injured worker. This firm is an example.
Yes. Yeah.
We are a small business. Okay, so let's take a look at an example. In your packet, hopefully that is now available to everybody. If you take a look at example 3, this is Outchit's wages again, but our employer has provided us with a putative similar worker. All right, so you can see this individual, Dill Egent, he earned, I do love puns, he earned $63,120 during the year prior to the injury and worked for 262 days. So we're going to calculate the average weekly wage using the similar worker payroll. And then we'd also like you to think about any differences that you might identify between Outchits and Dill Egent based on the factors that we just looked at.
And what we're really doing is we're drilling down to explain why claimants counsel really want us to produce similar worker payrolls whenever possible. They really want them because almost invariably something is either missed or it ultimately will end up leading to a higher average weekly wage.
In all likelihood, yes. So let's take a look at our calculations and see if we were able to identify some differences.
So look, this person's average weekly wage, $1,204.58 based off of the 260 multiple, right? But we have some differences. And if we look at what we learned about diligence is listed as a regular worker or a regular laborer, regular laborer. And then what is is a day laborer? Is that the same or different? What does that mean? Sometimes that has a significant difference. Sometimes that means that one could be hired and part of a unionized workforce and one wasn't. One was a casual worker and one wasn't. One was per diem and one wasn't. We may not know that based on those titles alone, and it could represent a significant difference. Their schedules are obviously different because it looks like their earnings are substantially different. Our claimant has a wildly varying earnings, even though we know they're an hourly employee over a weekly basis. But Diligent makes $1,200 a week every week. So it looks like Diligent has a really fixed schedule. And their yearly earnings are vastly different. Diligent's making more than $10,000 a year more than Outchit Hertz. Why? I'll tell you why. Well, maybe I can't. Mixed company. Diligent doesn't have a comp claim. Outchit Hertz does.
So what we're exploring here with you today are ways to identify areas on the C-240 and areas within how wages are provided and information is provided to the board to see whether or not there are other possible ways to calculate the average weekly wage. If all we had from our employer here was information regarding, we had a similar worker, that actually would lead to some savings over Outchit's original C-240 that was produced only showing 210 days. But we want to drill down into this even further and see if there are ways to calculate Outchit's average weekly wage, which are fully supported by the law, because that's important, that could lead to additional cost savings. So let's take a look at the statute again.
Reasonably and fairly applied. This
doesn't sound like comp.
This isn't used comp. 14.3 tells us if you can't use the multiple method of calculation to reasonably and fairly approximate their earnings, you can use such method of calculation having regard for the previous earnings of the employee to reasonably represent their annual earning capacity of that employee in the employment in which he was working at the time of the accident, provided, however, his average earnings shall consist of not less than 200 times the average daily wage. So you get two things from section 14.3, and the first one is often overlooked because the second one is the 200 multiple minimum. That gets a lot of attention because it's very clear. There's a lot of case law on it, and there's a lot of arguments about it because it tends to come up in calculation for casual, part-time, and seasonal workers. But the first part is the most important part. It basically says, if a multiple method of calculation does not result in an average weekly wage that reasonably reflects their earnings, e.g. that first example when I said, hey, that average weekly wage actually exceeds their earnings on all but 2 weeks of the 50 reported, that doesn't seem fair. You would have an argument under 14.3 to say that doesn't reasonably represent their earnings. You could come up with some other method of calculation.
14.3.
So we get an opening to come up with something else that might make sense, and we get our 200 minimum, right? Which is great. 14.3 is a wonderful tool, and it's probably the best single slide or section of the statute to illustrate everything we're trying to teach you in this whole presentation.
So when you're thinking about sections 14.1 and sections 14.2, right? 14.1, you have to have somebody who works substantially the entire year. The same is true for your similar worker. What is substantial? The other things that you could think about is who is a 5-day per week worker? You hire people and it's the it's the rosiest time of your employment relationship. And your expectation is when you hire them, you say, we expect you and we would like you to work 5 days per week. If Auschwitz was hired as a 5-day per week worker, he is not living up to really his end of the bargain because he has not worked 5 days per week consistently throughout the year. There might be another explanation, though, as to why Auschwitz is not a 5-day per week worker. So we don't want to automatically indicate that somebody's a 5-day per week worker, even if that was the expectation when they were hired, because 5 days per week worker is a legal conclusion that is determined by the Workers' Compensation Board in assessing which method of calculation you're going to use for an average weekly wage.
And just as if you flip back to the first page of any of the examples and you look at question 4, it asks the injured worker was and then there's check boxes. If you check 5 days, you are making a legal admission that, according to lots of cases, especially some more recent ones, will be used against you, regardless of what the data shows. There are many panel rulings that say, well, regardless of what the data shows, the employer checked the box to say they were a 5-day worker, so the application of the 260 multiple is supported by substantial evidence, and we're not going to disturb whatever was found below. And this is an unfortunate problem, and as part of the drive for this entire presentation is that this question is being asked with no context, usually to an employer who has no idea what it means. And so when Melissa says, well, they may have been hired as a 5-day worker, lots of the folks that are filling these things out don't understand why that question is being asked. And they just assume, well, there's 5 days in a work week.
And we would love it if they showed up for 5 days.
Yeah. And so they're a 5-day worker. They don't understand that explain, like per diem isn't an option on here. And it probably should be, given the volume of, say, per diem healthcare workers that we encounter.
There are tons of them.
Or per diem laborers that we encounter.
Grocery store employees, shift workers in factories, they could work 3 days. Nurses.
Anyone who's a shift worker at any sort of industry, especially ones like, as you point out, food service, healthcare, labor, they don't have a fixed schedule. They're called in and scheduled based on the needs of the business. It might end up being 5 days a week. But that's not true. They were not hired as a 5-day worker in anything but the most abstract sense of the word. This is a legal conclusion based on what they actually did.
So what we want is you, if you're filling out the C-240, or you, if you're obtaining C-240s from employers, is to have them think carefully about whether or not somebody should actually be characterized as a 5-day per week worker. If they were hired with that expectation, there's nothing that says that you can't put that clarification on the form, and then that could lead to us having ammunition to take the position that the person, although they were hired with that expectation of being a 5-day per week worker, didn't actually become a 5-day per week worker based on the facts.
there's nothing that says you can't check the other box and write shift worker scheduled as needed, right? That because what they might actually do in reality, especially for the group of people that we tend to see who have comp claims, they're going to have very, very odd and basically uneven schedules.
So let's take a look at a C240 of somebody's who, or we're going to now look at Outchits actually, where we went back to our client or to the employer, and the employer clarified, well, day laborer is actually somebody whose schedule can vary from week to week, and they're used on an as needed basis compared to a regular laborer who's scheduled to work 5 days per week. And if we had 5 days of work a week, we'd love to have them be there for 5 days. But as a practical matter, they're really on an as needed basis. So if you look at example 4 now in section example 4 in number 4, you'll see the other box is checked and it just says schedule varies. This is going to change the entire basis that we have to argue for an average weekly wage at the board.
Right, because we're not stuck with the admission of 5 days a week. So if we do the math, we again, for $52,920 earned, 220 days worked. If we use an actual multiple, that's to say, instead of using a 260 multiple, we're going to use a 220 multiple. We're going to then divide by 52, and we're going to calculate using this other method, actual multiple method, allowed under section 14.3. The math here, this is where it's like we go back to algebra, like 3rd grade algebra. Since we are multiplying by 220 and using an actual multiple, right? That means that we've now multiplied and divided by 220 on opposite sides of the equal sign in the same equation. And what does that mean? They cancel out. You don't have to do those operands. All you end up doing is dividing by 52. However, if you try and say that in a writing to the board, you will get corrected because there is no such thing as a divisor.
So that's why we highlighted in this formula for doing an actual multiple calculation, the number of days worked. You're going to divide by the number of days worked times the actual multiple, which is again the number of days worked. That's really just the number 1. You're dividing by the number 1, and then you're dividing by 52. So it's really a 52-week divisor. So let's calculate what the average weekly wage would be using an actual multiple for Outchits, now being able to take the position that he's not a 5-day per week worker, but that an actual multiple should be used instead.
And you have a valid legal argument to make this position because 14.3 says it has to be a reasonable representation. And we know that the 260 multiple generates an average weekly wage that exceeds every week that he actually worked except one, which is obviously not a reasonable representation of his earnings. And what do we get? 1017.69. What's the difference, by the way, guys? 1017.69? Wow.
So if you think about the different ways that we've calculated the average weekly wage so far, we started with Outchits wages where we didn't have an explanation for why he would receive wages a couple of weeks where there were no days of work listed. And that led to an average weekly wage of $1,260. If we do the proper and reasonable and fair method of calculating his average weekly wage and arrive at $1,017.69, there are savings of $242.31 on the average weekly wage. The same thing as if you include the PTO, you're saving $185.04 a week. And even if you use the similar worker in this instance, you could save $186.89 because that 260 multiple for Outchits is so skewed. It is not fair or reasonable to use a 260 multiple for Outchits wages on that first C240 because he only worked 210 days a year. And as James explained, he basically got credit for working 50 days that he didn't actually work.
And I just want to take a moment to point out that the C240 that we showed you in example 1 is not uncommon.
It's not hyperbole.
This is not hyperbole to demonstrate a point. This is what 8 out of 10 of them look like that we run across. They worked between 220 and maybe 240. There's a couple of zeros in there. There's weeks with earnings and no days. This is not an oddity. This is what you commonly will run across. If we see it that often as an adjuster or a claim handler in any sense, you have to see it 10 times more often. And if you can imagine death by 1,000 cuts, if you could just change the checkbox from 5 days to schedule varies on half of those, or get clarifications on why are there earnings and no days, or what actually these people do, or why is this worker similar or not, these savings could add up vastly just across a small handful of claims.
And we're going to look at that now, because you might be asking yourself, James, Melissa, why am I going to go through all this extra work to get back to the employer in order to get this additional information that we need? And we're going to point that out right now by taking a look at the impact that these savings can have on your claim. We know there are 5 different kinds of disability benefits that you can get at the Workers' Comp Board: temporary partial disability, temporary total disability. You can get a schedule loss of use award, which is technically also a permanent partial disability award, or you could be classified as permanent total.
Well, if we want to calculate the temporary total rate, if we use the average weekly wage of $12.60, you're going to see that we're using an AWW 1260. The max rate is $1125.46. We're going to just use an older rate to show what that is.
The date of accident actually is listed on Outschutz wages, so we're using the date of accident, the maximum for that date of accident, based on the average week, the accident date for Outschutz wages.
Yeah, we just wanted to make sure that we pointed out that we still remember that their max rate
yes.
is in effect
very
on
important,
these cases.
Especially with the minimums, the way they're creeping up.
Yep. So you're going to see that if you calculate 2/3 of that AWW, it's $840, right? So that's a lot. Well, let's see what it looks like though when we start calculating it on other rates.
So the TT rate, we're going to calculate the TT rate now using that lower average weekly wage that we were able to obtain by going back to our client and asking some questions and ascertaining that actually he wasn't a 5-day per week worker. His schedule varied. Take 2/3 of 117.69, subject it to the maximum for that date of accident. You'll get a temporary total rate of $678.46.
That's a lot. That's a lot of difference.
Again,
that's a big difference.
Let's take a look then at how this impacts the permanency awards that you can face in connection with a claim.
Yeah, I mean, we know an arm is worth $312, a hand $244, a leg $288, a foot $205. Those are weeks of benefits. So at 10% of any one of those is going to give you, like, for example, 31.2 weeks for an arm. 10% of an arm isn't big. It's sometimes you're happy when it's a 10% of the arm. But it could be more than that. So we're looking at now the butterfly effect, right?
So to take a look at our savings, we're going to apply this to an example of a schedule loss of use award, which everyone will remember. You take the total number of weeks that are available for an extremity, and then you multiply it by the percent loss. So let's take a look at a specific example here with the 2 different average weekly wages that we established.
There's so much math on this screen. It's more than
I know, but we're just going to talk about it.
Yeah, the short of it is 20% SLU using that higher average weekly wage, that first one we calculated where we were not able to do any sort of cleanup or improvement. That schedule is worth $52,000.
So now let's take a look at what the schedule would be if we used the $1,017.69. So same permanency, but you now have reduced your liability by almost $10,000.
Huge difference.
Or excuse me, a little bit over $10,000. Right. So the question is, why do I want to? Why is this worth it to me? The answer is, it is worth it. If you believe that $10,000 is worth the amount of time that it would take in order to have your client give you the accurate information for the average weekly wage. Let's take a look at a non-scheduled permanent partial disability.
This is just the cap chart.
Yep.
We're just showing you the cap chart.
This is to refresh everybody's recollection. When you have a non-scheduled PPD, you look at the percent loss of wage earning capacity, and that entitles a claimant to a certain number of weeks of benefits payable at a weekly rate, which sometimes, usually, always matches the loss of wage earning capacity. So let's take a look at our examples again.
Well, if we have a 50% LWEC on a PPD, that's 300 weeks at that $1,260 average weekly wage. This is the bad average weekly wage, the one we don't like the most. That cap is worth $126,000. Now, if we adjust it and we get our 1017 average weekly wage, right, the one that we like, we've done a little bit of a little bit of work.
Mhm.
We've got the 1017 average weekly wage, 101 grand. That's a huge, huge difference.
In fact, it's savings of $24,000. So you can see how small differences in the average weekly wage that might not seem like they're going to be that important can lead to really big savings. Now think if you could save $10,000 on every claim that comes through the door, you're talking about really significant savings.
And I just want to make an aside real quick. If you sort of think back, as we're talking about savings, when we calculated the total rate for the $1,260 average weekly wage, it was over $800. If you look at Ouchit Hertz's C240, that's about what he made on most of the weeks that he actually worked. So if Ouchit Hertz is out TTD, he's actually making the same amount of money that he was earning.
Where's the incentive to return?
Right. There's that strikes me as a serious problem.
Yeah, most of our employers want employees. That's why they hire them.
Yes.
Oops. Okay, let's take a look at part-time employees now. So we gave you some examples on just looking at how you can reduce it for a particular full-time employee or somebody who had the expectation of being hired full-time. What we want to do now is examine those situations where you have part-time employees. We're back to section 14.3, right? Because they are not a 5-day per week worker, they're not a 6-day per week worker. So you want to use section 14.3 to calculate an average weekly wage that can be reasonably and fairly applied. This is an example in your book. Example number 5. Okay.
Right. So we have
Gen Y.
Gen Y. And if you look at just the second page of the C240, you're going to see their days worked a week are scattered all over the place. There's as many zeros as there are 4s, and there are very few 5s, mostly 2s and 3s. We clearly have somebody who's a part-time worker in some way, shape, or form. Gross wages of about $20,000, 124 days worked. If you apply the 200 multiple, you're crediting them with 76 days that they didn't actually work.
But according to the statute,
that's what you do.
That's what you do, right? So back to section 14.3, this is where that exception, the floor for an average weekly wage, is going to apply. That the average annual earnings cannot be less than 200 times the average daily wage. So it says that the floor for this individual has to be the 200 multiple. So let's calculate what Gen Y's average weekly wage would be, first using the 124 days to figure the average daily wage, and then subjecting that to the 200 multiple floor.
There we go. 19,840 gross earned using a 124 multiple, or 124 days using a 200 multiple floor. The average weekly wage is $615.38 a year.
Going back to James's point to take a look at what Gen Y actually earned each week that she worked, and comparing it to the average weekly wage of $615.38. Again, there are barely any weeks where she worked and exceeded that amount during the year prior to the injury.
Yeah, the highest she earned on any single week was $800, it looks like, for 2 weeks of the year. And 3 weeks of the year, she earned $800. The data mode is 640. So 615 ain't all, or 618 ain't all that much lower than 640, which is not, it's not even really the mode. Most of the time she earned $320 to $480 a week.
So let's examine whether or not there's another way that we could calculate her average weekly wage so that it reasonably and fairly represents her annual earning capacity.
I call this a golden boy case because he filed a claim against his dad's own business. And he worked there like 1 day a week doing something, who knows what. And he had a comp claim, and he wanted the 200 multiple because it was going to inflate the value of his case, because he really didn't work much at all. He just apparently walked in, counted his dad's money, and then walked out and somehow slipped on the way. And then this comp claim ends up going to the third department.
I've never not believed that this couldn't have been collusion between the son and the dad.
Yeah.
To get him that Trans Am that he wanted.
Maybe. But at the end of the day, this case goes to the third department, and the third department tells us that there is a case law driven exception to this rule. It is a floor, but the claimant has to have been fully available for employment. The system is not designed for sort of casual people who are working like 1 day a week because they want to. There are cases dating back into the way back into the 40s and 50s that talk about election poll workers who are retirees who work 1 day a year. The system is not designed for that. It's not meant to accomplish that sort of compensation, because the system is designed to compensate somebody for every day that they could be working, but they're not. But that could be working part is where Kellish comes in. If you could be working but didn't want to, we're not going to calculate your average weekly wage in a favorable way.
So the key language here is whether or not you're fully available for work. And to determine that, we can look at some Kellish factors, which is, did the claimant work for any other employer? Is the claimant fully available or not because they're enrolled in school or because they're caring for a sick relative? Has the claimant
But the reason why is almost irrelevant.
turned down
You don't
any
want them to say why.
shifts for work that were offered to them when they were hired? Did they say, I can only work Monday, Wednesday, and Friday from 9 to noon? I can't work Tuesdays and Thursdays, and don't call me on the weekends. So the question is whether or not the claimant was fully available for work, and we have to go back to our clients, to the employers, in order to get that kind of information.
And if you have good counsel, this is one of those great legal positions. I like the facts of these particular mini litigations.
Easy trial.
Yeah, because if the employer comes in and says, we had other hours, they just didn't want them, you win, or you should win. If the employer says, we didn't have other hours, but they were hired to do exactly what they did, and they did actually probably less than that, then you go to the claimant and go, well, what else were you doing? Nothing. You win, or you should win, right?
Right.
It's one of those cases where a claimant would have to make a really strong affirmative showing that they were doing as much as they could to fill up their time and earn income.
That they called the employer and were trying to pick up extra shifts, or that they were looking for work and they weren't otherwise employed.
And 9 times out of 10, you're not dealing with a concurrent employment situation, which means they weren't otherwise employed. So they would have to demonstrate that they were actively seeking some kind of work, and they don't have records of that. They're just going to say that.
So let's take a look at an example again. So we're going to go back to our number 5 in your packet, and we're going to apply the Kellish rule to this individual. We've ascertained that she wasn't fully available. So instead of using a 200 multiple floor, just like with 14.3 we saw with a schedule varies outchits, we're going to use the actual multiple to calculate her average weekly wage. So calculate her average weekly wage, and then we want you to take a look at what the difference is in her average weekly wage compared to when we use the 200 multiple versus when we use the actual multiple. So we'll give you a minute to do that. We'll take a breath.
I don't need a breath. I'm a litigator. I'm just going to keep talking until I drop.
I know. Nothing makes James more uncomfortable than not being able to talk. Silence.
Must fill the void. All right. So our average weekly wage, right, on a 200 multiple, 300 is 618.38. If we apply the Kellish exception, if it turns out they weren't fully available and we use a 124 multiple, the average weekly wage is $381.54 for a difference of $233.84 per week. That is huge.
Enormous. In fact, let's take a look at how huge that is. If you have a 20% schedule loss of use of the arm, like we did with outchits, that's going to lead to savings of $9,727.94. I mean, again, is it, worth it to get that information and to ask your employer to work with you in order to provide evidence that the individual wasn't fully available for employment?
Look at the difference too between.
It would be worth it to me, I'll tell you that much.
Look at the weekly. Look at the weekly difference. CR of 254.36. If you calculate the average weekly wage, accurately reflecting what they actually earned, as opposed to using a multiple method of calculation and crediting them with 76 days of employment that they didn't make. 76 days of employment. It's like 2 months of work that they didn't do, that the comp system wants to compensate them for, simply because, I don't know, I didn't write the statute, I wasn't there, but it couldn't have been good. And now we're going to take steps to, and this is not about manipulating the system.
No,
this is about
the law.
This is about following the law. This
Right.
is about taking, if you can, 5 or 10 minutes at the outset of the claim and sort of validating this before you produce it.
Let's take a look at the savings that you would get if there was a permanent partial disability classification with a 50% loss of wage earning capacity. Again, we're looking at savings of $23,000. So we believe that it's worth it to do that extra effort to fully explore possibilities in your producing your average or your C240s to explore whether or not there are ways to reduce your liability. Well, that is our presentation for today.
Almost exactly 45 minutes.
That's perfect.
15 minutes.
15 minutes.
Questions.
Yeah.
Yeah.
I'm not sure that we have the capability to have questions asked from our attendees.
Is the chat open?
We certainly could have questions.
Okay.
Oh, that'd be great.
Yeah, chat is open if you want to throw it in the chat because you don't want to say it.
If you want to throw it in the chat because you want to be anonymous, or if you want to ask a question, you will be unmuted now. Now.
Are they unmuted? Did you unmute everyone?
No, I mean if they raise their hand.
Oh yeah, I guess you use the raise your hand feature.
Individuals.
I see. You could just unmute everybody because, yeah.
I want to hear who's listening to music during the presentation.
Yeah, who's got the dog barking in the
Snoring.
background? Who's snoring?
Who fell asleep and is snoring?
Probably a lot.
I'd be snoring, drooling on my computer if it were me.
All right, so does anybody have any questions that they'd like to ask? All right, I think everybody's excited to be done a little early here. So what I would ask you to do is if you have any questions that you would like to submit after the chat, please email James or me. At the moment, while we do have our webpage address listed there for you, we've been having some technical difficulties with our webpage over the past couple of weeks. I know there was some malicious malware that affected our website, so we're in the process of getting it rebuilt. But James and I are always available.
There's only some malicious malware in my head.
There's quite a lot of malicious malware in my head. So feel free to give us a ring, to contact us by email, and we'll be happy to answer any direct questions that you have. And thank you very much for your attendance today and for participating. And we hope to see you on our YouTube channels and at any local events that we attend.
Thanks, everybody. Have a great weekend.